Do you remember the OJ Simpson trial? For some of the younger folks out there, you might have to Google this. The rest of you, I'm sure you remember it. You were there watching it just like I was. By way of review, you know that OJ hired the best attorneys that money could buy. In fact, I think he made an entire Kardashian thing happen later on, but that's besides the point. He had his attorney sell a jury of 12 people a story that got him off the hook despite basically overwhelming evidence against him showing that he had murdered his wife and her alleged lover. The trial dragged on for weeks, then it dragged on for months, and as the attorneys trotted out piece after piece of evidence to support the case, the entire nation hung on every detail for 9 full months until they got the famous not guilty verdict that was ultimately rendered by that jury. But think about it. What if OJ's attorney got up there and instead of building this meticulous case like they did, they just spewed out a bunch of platitudes? What if they said, hey, you know what? He couldn't have done that. He's OJ, man. He's the juice. He runs through airports. He's the 2,000-yard Buffalo Bill. This dude's a movie star. There's no way he did this. He wasn't even there that night. He was somewhere else. There's no way that OJ could have done it. What if the attorneys had just said stuff like that? I mean, it's ridiculous, obviously, but here's the truth. That's about as good of a case as most businesses prepare to defend and sell their products. They just offer non-compelling, surface-level laundry list of platitudes and hope that somebody's going to give them their money, as if just being there, just being a business makes them entitled to it. My name is Rich Harshaw. I'm the founder and CEO of Level 10 Contractor. We specialize in generating 2 to 500 leads monthly consistently for remodeling and home services contractors. Got 30 years of experience. I have a book called Unlocking Unlimited Lead Flow. I've helped hundreds of contractors escape the feast or famine marketing that maybe is plaguing you. Today, we escape like OJ. Look at what OJ's attorneys did. They didn't rest on OJ's reputation. They got to work. They got all kinds of forensic reports, alibis, expert witnesses, and everything to prove that he couldn't possibly have done it. It wasn't OJ. He didn't do it. They defined the most important issues and brought in experts to teach the jury what they needed to know about these issues. So for instance, I don't know if you remember this, they had a guy who was a glove expert, and he showed the jury how and why the glove that was found at the crime scene couldn't possibly have been OJ's. It was too small. Look how big that hand is. And then they had, you've heard of these guys, right? The blood splatter expert who testified that there's no way that the blood would have splattered this way if OJ had done it. Then they gave the jury a crash course on blood splatterology, or whatever you call that. You see, if OJ would have stabbed somebody or cut somebody, then the blood would have splattered over here, not over there. Then do you remember this? They had this shoe expert. He testified that those bloody footprints were not possibly left by OJ's size 12 Bruno Magli boots. It wasn't OJ. At least he wasn't wearing them. I mean, it was crazy. They had all these super experts. I mean, who ever heard of a glove expert or a blood splatter expert outside of a court case? I mean, they probably make good money for that weird expert knowledge. But you know what? After that testimony and all those witnesses, the jury felt like they knew just about enough about gloves and blood splatter and the relevant issues surrounding the OJ Simpson case, Bruno Magli shoes, that the lawyers were able to get him off scot-free. So here's the thing that you need to keep in mind. Your prospects don't know what to look for when it comes to buying whatever it is that you sell. If it's windows or roofing or siding or HVAC, bathrooms, electrical services, they don't know. And that's the jury. They're the jury, and it's up to you to win them over. You can't just throw out claims either. You have to educate the jury. You have to show them evidence, and you have to prove that what you're saying is true. Think of your business like this. Your business is on trial because it is on trial in the court of consumer opinion. Your product or your service is the defendant. Your customers, the prospects, those are the jury. In your marketing, it's like you're an attorney and it's a life or death sentence. It's really just that simple. If you can prove your case, you're going to have a good chance of winning. You're not going to go to prison at least, but you're going to lose, all right? So here's what we've got to understand as you go out and do this marketing stuff and start to try to educate the jury, so to speak. It's really important that you understand that the jury does not know what to look for. They don't understand jack squat. They don't know. That's why OJ's attorneys didn't just say, look, the gloves prove that he's innocent. That's like your business saying, hey, buy from us because we have high quality. No. Instead, they explained why the glove was important, how the sizing of glove affects the fit, and specifically why and how that specific glove couldn't have been OJ's. They had experts and they had them testify. Okay, so you're going to need to challenge yourself to hyper specificity so that you can educate your jury. You need to find the things that are unique and different and interesting and relevant about your business and start pointing at them. I'm going to give you an example. I worked with a roofing company and they insisted that their identity would be based on how meticulous they were about quality. Okay, good start, whatever, but you need to be more specific. So then I questioned them more, and actually I kind of beat the living daylights out of them like I tend to do. And they said that they follow the manufacturer's installation guidelines to the T. All right, now imagine a radio ad. Hey, we follow all manufacturing guidelines to the T. It's gonna work. It's boring. Nobody freaking cares. Now, this is when I bring out my hammer and I start really pounding, or my shovel and I start digging, depending on which analogy makes the most sense to you. I asked them this question. Give me one good example of following these guidelines and why it matters. And they said immediately, well, we use 6 nails per shingle, like the manufacturer specifies. Okay, so how many nails would other roofing companies use? Oh, well, they maybe would only use 3 or 4. Okay, so what? Technically, if you only use 3 or 4 nails instead of 6, it voids the warranty. Okay, but does it cause any actual damage? Like, is the roof actually worse off if they only use 3 or 4 nails instead of the specified 6? And man, they almost lost it. Yes, of course, they said cutting back on the nails weakens the entire roof, makes it far more susceptible to wind damage, hail damage, other natural wear and tear. Okay, but does it affect the lifespan of the roof? And if so, by how much? And then they looked at me like I'm an idiot because, they said, of course, our roofs last the full 30 to 50 years that they're warranted for, depending on, which type of shingle. And the other guys, when they cut those corners, nails, not enough nails, their roofs might last 20 years, but typically they're only like 4, 5, 10 years. Okay, that's a big difference. Okay, so why would the other guys cut those corners? I mean, I know it probably saves them some time and some money, but how much? And they thought about it for a minute and they said, well, probably on a standard roof, it might save something like $12 to $20 on nails and maybe $100 on labor because, you got to nail less times. Maybe more than that. They weren't quite sure. And I said, okay, so what you're telling me is that by the roofing company cutting these corners, they might save $100, maybe $150, $200. Is that right? And they said, yeah, at least. That's it. Okay, so how would a customer even know if they're being cheated on by this nail shortage like that? And they looked at me and they said, well, they would never know. I mean, when the roof starts to go bad, they would probably not even suspect that it was a nail problem. Okay, so then I asked them, are there other things that contractors might cut corners on too that would also save them a few more bucks here and there that would add up to, a lot of money on a given roof? And they almost peed themselves as they started listing all these things that roofers do to cut corners. Let me just give you an idea of what that might sound like on a radio ad, okay? It might sound something like this. Hey, Robert or Larry here from ABC Home Improvements, and I want you to know that it's the little things that count. Anyone can say that they treat their customers right. When it comes to roofing, siding, and windows, it's hard to know for sure if a contractor is treating you right or not. If a contractor uses 4 nails per shingle when they're supposed to use 6, how would you ever know? If a contractor uses a cheap $4 tube of sealant on your new windows instead of paying $9 for a tube of the good stuff, could you tell by looking? It all comes down to the details and trust. At XYZ, whatever their company was, Home Improvements, I can't remember what it was. Anyway, we only do things one way, the right way. We never cut corners. We never skimp on details. We never do less than the job requires. That's why we offer our best warranties in the industry, and that's why we have the happiest customers. If you're in need of roofing or siding or windows, give us a call. Then you give the contact information, etc., offer, right? Boom. Specificity, detail. Find them and share them, okay? You've got to educate the jury. Now, I had an interesting experience I want to share with you. It was in 1994. I was a young lad. I was only 25 years old, so do some math to find out how old I am now. And I was actually chosen to be a juror on a murder trial. I'm going to tell you about this because I think it's interesting and I think it's relevant to your situation with marketing. So just to give you a little background on this murder trial, it was a drug deal that had gone bad. The people involved were inner city youth. They had actually had this case that had gone down in the city that I grew up in. And I think it was within the bounds of where I went to high school, probably something like 4 or 5 miles from my high school. And it was in the bad part of town. Here's what happened. There was 2 cars that had pulled up next to each other in opposite directions. Okay, so the driver's side windows were next to each other, again, facing opposite directions. The kid, and they were like 18, 19 years old, so I'll call him the kid. I was only, 25 when I was on the jury. But anyway, the kid in one of the cars pulled out a sawed-off shotgun, stuck it in the face of the other kid, pulled the trigger, killed him, and then drove off. That's what happened. That's the very basic facts of what happened in this case. So as I sat there on the jury, they presented all of this kind of evidence to show what had happened, how it went down. And it was very interesting. I mean, obviously, it's very sad because it was a murder trial, but it was also interesting to kind of go through this process. Now, I'm going to give you a couple of details from that trial because it's going to illustrate the point here that we're talking about, which is educating the jury. One of the things that they did is they showed us photographs of the wound on the victim. And you could tell that you've got to imagine, he was in the driver's seat and there was somebody leaning in his window with this sawed-off shotgun. So he tried to lean away kind of like this. And as he did, he exposed his head and he was shot up under his chin like this right here. Okay. That's where the gun was put. The trigger was pulled. So basically, I mean, I know this is gruesome, but bear with me. It kind of blew off the bottom part of his jaw and his mouth and his fingers because he had put up his hands to try to, defend extensively. And apparently there'd been some money in his hand because there's also some money that had been shot as the trigger was pulled. It was very graphic. We looked at the photos. It was disturbing. The district attorney showed us these photos and he said, look, you can see here because of this wound, it was a shotgun blast. We estimate that it was a sawed-off shotgun because of the proximity and the powder and all these different kinds of things that they were specific to that, okay? So they brought out some other evidence. There's actually a witness, a gal who was driving on the same road and she just happened to pull up behind them and witness this whole thing. And she sat on the witness stand. It was almost like the proverbial bad lawyer show where she kind of pointed at the guy and said, yeah, that's the guy. He did it. I saw him do it. Then they had this other interesting. There was this kid in the car where the kid was shot. There was actually 3 people in the car at the time of the murder. There was the driver, and then there was 2 people next to him on a bench seat. You remember bench seats in cars? Okay, this happened back in the early 90s. I don't think they have bench seats anymore, but you might remember them. So there was 3 across anyway. That's the point. There was the driver, then there was a kid in the middle, and then there was another kid in the passenger seat. And again, remember, 18, 19, 20-year-old kids, okay? So out of those 3 kids, the driver was the one that was shot. He was the victim. He was the deceased. The kid who was in the passenger seat at the time, he was not present at the trial. He wasn't there. He was not a witness. I don't know why he wasn't there, but he wasn't. They didn't explain where he was. But the kid who had been sitting in the middle, right next to this kid who got shot, he was there and he testified. And kind of weirdly, he was in a wheelchair. It seemed a bit odd. And the attorney actually mentioned it. He said, hey, this guy was not in this wheelchair at the time of the incident. He has become dependent on this wheelchair since then, but it is not relevant to this case. Ignore the fact that he's in a wheelchair and just listen to what he has to say. Don't pay attention, to this wheelchair. But I mean, it was kind of hard to ignore. So this kid goes out there in his wheelchair and I mean, he was sweating, he was stuttering, he was like staring. This was the most nervous individual I've ever seen in my life. And he just sort of hemmed and hawed his way through his testimony. It was actually very compelling. I mean, you could tell that this guy was terrified to be testifying, but he was there doing it anyway. And of course, he said that it was the same person, the defendant, that the other witness had seen. And so it seemed like it seemed like a very clear-cut case. Now stick with me here. I'm kind of getting to the point here in just a second. I know this is kind of a little bit of an adventure here. So here's what happened. We went back into the jury room to deliberate, okay? And I think all of that evidence and testimony and stuff took something like a day and a half to go through. If you've ever been through a court case, there's a lot of nonsense stuff that happens in the beginning. So it was about a day and a half. So we go back to deliberate and I'm thinking, oh my gosh, this is like the most clear-cut opening shut case I've ever seen in my life. Of course, in real life, it was the first one I'd ever seen. But I've watched movies and I thought, we're going to be out of here in like an hour or something like that. So they took a preliminary vote where we did it on secret ballot where you wrote guilty or not guilty on a piece of paper, right? Okay. And we handed it to the foreman who was actually a woman, a 4-woman foreman. I don't know what you call that. Anyway, she counted out the votes and I could not believe it. 9-3, not guilty. And I thought, what trial were these people watching? This doesn't even make any sense. We got eyewitnesses, multiple eyewitnesses. We've got forensic evidence. I mean, we've got everything. This kid clearly did it. So we started debating and several things came up that were interesting. But there's one thing that I want to focus on. The person who was the 4-woman, whatever, she was very adamant that this kid had not done this. And she did not want to believe that he possibly could have done it. And so she was looking for any kind of evidence to support the fact that he didn't do it because she didn't want to send what she called an innocent kid to prison. I'm not sure how she thought he was innocent, but whatever. I mean, he was a kid, so that's sad. I mean, it's sad when anybody kills somebody. But anyway, she felt that it was going to weigh very heavily on her if we sent this kid to prison, okay? And here's the part that was really interesting. She said, well, how do we know that it wasn't somebody else that shot him? And I said, well, we've got all the eyewitnesses. And I kind of became the advocate for he's guilty, okay? And she said, well, we don't know that. It could have been somebody from across the street that was, behind a tree or something and shot him from behind this tree across the street. And I said, no, that's impossible. She said, well, you don't know that. I said, well, actually I do. I looked at the evidence. And she said, what are you talking about? The evidence doesn't say anything about how far away the shooter was. And I said, yeah, it does. We looked at the pictures, remember? And she said, well, the pictures don't prove anything. I said, the pictures actually prove a lot. It proves that he was shot at close range by a shotgun, most likely a sawed-off shotgun. But even if not, it was clearly a shotgun blast. There's no way that came from across the street. If it came from across the street, that buckshot would have spread so thinly that it barely would have peppered the car. I mean, it certainly wouldn't have been the wound that we saw in those photographs. And she said, well, you don't know that. There's no way you can know that. And then it dawned on me right there. She didn't know the difference between a rifle and a shotgun. Now, I've told this story at seminars before, many, many times, in fact. And I always get a few people looking at me like, what do you mean the difference between a rifle and a shotgun? So I always get into a habit of asking, if you don't know the difference between a rifle and a shotgun, raise your hand. And usually anywhere from about 5 to 20% of the audience, let's call it 10 to 15%, pretty typical, they don't know the difference between a rifle and a shotgun. Now, I know the difference between a rifle and a shotgun, not because I'm some sort of a gun expert, but I was a Boy Scout and I went to scout camp and I took rifle and shotgun merit badges. I've got them both. They're on a sash somewhere in my parents' closet somewhere. And look, I know darn well that you can't stand across the street behind a tree with a shotgun and shoot somebody and produce the kind of wound that we saw in those photographs. If you know anything about shotguns, you know what I'm talking about. I explained to them that it was clearly a shotgun. And I explained to them the difference between a rifle and a shotgun. And it turns out that out of all of the jurors, I was literally the only one that knew the difference between a rifle and a shotgun. Now, that jury consisted of 9 women and 3 men. And typically, when I'm at seminars, and I ask who doesn't know the difference between a rifle and a shotgun, it's typically women who don't know. I'm not trying to be sexist. I'm just reporting what I've observed. Generally, it's women that don't know the difference. And trust me, there's a ton of women that do know the difference. Like I said, usually only about 10 to 20%. But in that particular group, all 9 women and the other 2 men, they did not know the difference. I, fellow juror, had to explain it to them. And I thought, wow, this is amazing. We've got a murder trial. Literally, life and death on the line here. Well, maybe prison. We got a kid who's going to go to prison for a long, long time. And the attorney never bothered to describe the difference between a rifle and a shotgun. So it allowed the jury in their own minds to believe, in absence of me being there, at least I was there to set them straight, that wound could have been caused by any kind of a gun and it could have come from anywhere. They didn't understand that it had to be a shotgun and it had to be at close range. Here's the point. Hopefully it's clear. You've got to explain to the jury exactly what it is that they're looking for and exactly how to interpret it. I'm going to give you another good example. Okay, this one's windows. Don't worry, it's not gory this time. There's a really important number attached to a window. It's called the U factor. You probably know what a U factor is if you're in that business. If you don't know what a U factor is and you're in the window business, I don't understand that. I don't know, maybe you're a kitchen remodeler, you're not really up on your factors. But here's how it basically works. The U value is going to be anywhere from about 0.18 up to about 0.40. Okay, 0.40, that's not good. 0.18, that's really, really good. So that's the range, all right? So here's what we've got to do. We've got to explain that to people. And you say, well, I'm going to explain to them when I get into the house and I start going through my sales presentation. And I'm here to tell you, it's too late. We got to educate people in the ads, in the website, before they ever call us. Victory goes to the one with superior forces at the point of contact. I've said that thousands of times over the years, but here's what I really want to point out now. And this is something that you want to focus on your website, on your core pages, on your website, in your diggable content. You want to start to educate people on the various elements and the specificity of the things that you want them to know and understand. And you've got to describe it to them in as much detail as is necessary, okay? So that they understand rifle versus shotgun, for example. 6 nails versus 4 nails, for example. Why it matters. 0.20 U factor versus 0.28 or 0.40 U factor. Why does it matter? A $6 tube of sealant versus a $2 tube of sealant. Why does it matter? Faucets that weigh 10.5 pounds versus faucets that weigh 1.5 pounds. It matters, right? These are things that people don't tend to understand, and we've got to explain it to them, okay? So what's the one thing about your business that your customers absolutely need to understand but probably don't? Leave a comment below. Let me know what it is. Whenever I tell this trial story at seminars, the murder trial, people always want to ask a follow-up question, and you might be having the same curiosity, so let me fill you in. They always want to know, well, what happened at the murder trial? Well, funny thing, after 4 hours of deliberations, I was able to swing 3 of those jurors in favor of guilty, so it was 6-6. Then we went back at the judge's orders and deliberated another, several hours. And after something like a full day of deliberations, it was completely deadlocked, 6-6, and the judge called a mistrial. So everything that we did was completely thrown out. Ostensibly, they did another trial later, which I don't know what the outcome was. But I will tell you an interesting footnote about that. You remember the kid that was in the wheelchair that testified? Remember I said he was super nervous, he was sweating and stuttering? Here's what I found out after the trial, because, remember, they weren't allowed to say this during the trial. That kid was actually in a wheelchair because he was shot at point blank range with a handgun to the back of his neck, which is what paralyzed him and put him in that wheelchair. And I'm assuming it was intended to kill him, but it only paralyzed him, okay? And the person who had done that was, guess who? The defendant's brother. But this was inadmissible as evidence because the brother who had shot him allegedly was still awaiting his trial for that crime, and as a result, it had not been proven and could not be discussed or admitted as evidence in this case. Crazy stuff. But here's the bigger point, not to give you more details about a murder trial, but to help you understand when it comes to your products and services, it's not just important, it's critical to educate the jury, to help them understand the difference between quote unquote a rifle and shotgun, or in your case, understand the details of what you do, how it's different, why it's better, so that they can become, if not experts, at least functionally literate in the things that you need them to understand, so that they can understand and appreciate that you are the best value, that what you sell is the best choice, and so that you basically just want them to decide to do business with you. This is pretty hardcore. I mean, the part about the kid in the wheelchair who had been shot in the neck, and really 11 out of 12 people in Texas, for crying out loud, didn't know the difference between a rifle and a shotgun. Make sure you're educating your juries, people. They do not. I repeat, they do not know even the slightest thing about your business and how you do things and what they need to know. Educate your prospects and watch your sales and influence grow. Check back with us every week. Hit that like and subscribe button. Get on this channel. You don't want to miss any future episodes, so click the bell. You'll be notified when the next video comes out. In the meantime, if you're tired of guessing at marketing and you want a reliable 200 to 500 leads every month, Level 10 Contractor is your partner. Visit us at level10contractor.com.